Hello, good morning, guys. So, today my group and I will be presenting about arbitration and other alternative dispute resolution.
What is arbitration? Arbitration is a procedure in which a dispute is submitted, by agreement of the parties, to one or more arbitrators who make a binding decision on the dispute. In choosing arbitration, the parties opt for a private dispute resolution procedure instead of going to court.
So, as we get to know what arbitration is, we will be talking about the nature of arbitration. So, arbitration is known to be neutral as its main principle, and the procedure of arbitration is proceeded confidentially. And the arbitrator chosen by the parties will be involved a lot. Lastly, arbitral tribunal is final. So, as we know, arbitration is consensual and is also a confidential procedure. According to the WIPO rules, also known as World Intellectual Property Organization, specifically protects the confidentiality of the existence of the arbitration, any disclosures made during that procedure, and the award. In certain circumstances, the WIPO rules allow a party to restrict access to trade secrets or other confidential information that is submitted to the arbitral tribunal or to a confidentiality advisor to the tribunal.
I'm going to talk about litigation. Litigation is the process of taking a dispute to a court of law. If parties cannot agree between themselves about the fair and proper outcome of a dispute, they will present their respective cases to a court for its judgment. It is a broad term that describes a long and sometimes complex process. There are five cases in litigation. First one is commercial disputes. It claims for breach of a contract such as damaged goods or recovery of debt. Second one is matrimonial matters, determining the extent of a spousal claim in a divorce action. Third one, claims against the state, judicial review of planning decision. Fourth one is personal injury claims, monetary claims arising out of an accident where a person suffered harm. And the last one is employment disputes, a claim for wrongful dismissal.
Laws of the Republic Indonesia number 30 of 1999. Non-litigation method for dispute resolution. The settlement of business disputes is mostly carried out using litigation or dispute resolution through the trial process. Settlement of the dispute begins with filing a lawsuit to the district court and ends with a judge decision. Settlement through non-litigation is the settlement of disputes that are carried out using methods that exist outside the court or using alternative dispute resolution institutions. In Indonesia, there are two types of non-litigation settlements, namely arbitration and alternative dispute resolution in accordance with Law number 30 of 1999, arbitration and alternative dispute resolution. In the Constitution of 1999, Chapter 1, number 30, it says that first, arbitration is a way of settling a civil dispute outside the general court based on arbitration agreement made in writing by the parties to the dispute. Second, the parties are legal subjects, both according to civil law and public law. Third, an arbitration agreement is an agreement in the form of an arbitration clause contained in written agreement made by the parties before a dispute arises, or a separate arbitration agreement made by the parties after a dispute arises. Fourth, district court is a district court whose jurisdiction covers the residence of the respondent. Fifth, the petitioner is the party submitting the request for dispute resolution through arbitration. Six, the respondent is the opposing party to the petitioner in resolving disputes through arbitration. in the Constitution of 1999, Chapter 2 and Chapter 3, Number 30. First, this law regulates the settlement of disputes or differences of opinion between parties in a certain legal relationship who have entered into an arbitration agreement which expressly states that all disputes or differences of opinion arising or which may arise from said legal relationship will be resolved by way of arbitration or through alternative dispute resolution. Second, the district court is not authorized or adjudicate disputes between parties who are bound by an arbitration agreement. In the Constitution of 1999, Chapter 5, Number 30. First, disputes that can be resolved through arbitration are only disputes in the field of trade and regarding rights which, according to law and regulations, are fully controlled by the disputing parties. Second, disputes that cannot be resolved through arbitration and are disputes that, according to laws and regulations, cannot be reconciled. In the Constitution of 1999, Chapter 6, Number 30. First, civil disputes or differences of opinion can be resolved by the parties through alternative dispute resolution based on a good faith by excluding litigation in the district court. Second, settlement of disputes or differences of opinion through alternative dispute resolution as referred to in paragraph 1 shall be resolved in a direct meeting by the parties within a maximum period of 14 days and the results shall be stated in a written agreement.
Chapter 7 and Chapter 71, Constitution 1999, Number 30. The parties can agree on a dispute that has occurred or will occur between them to be resolved by arbitration. And a request for annulment of the arbitration award must be submitted in writing within a maximum period of 30 days from the day of submission and registration of the arbitration award to the registrar of the district court. Now, Chapter 59, Constitution 1999, Number 30, which states that within a period of 30 days from the date the decision was pronounced, the original sheet or authentic copy of the arbitral award submitted and registered by the arbitrator or power of attorney to the registrar of the district court. Submission and registration as referred to in paragraph 1 carried out by recording and signing at the end or on the sidelines of the decision by the registrar district court and the arbitrator or his attorney who submitted, and the records is the registration deed. The arbitrator or his proxies are obligated to submit the decision and the original appointment as arbiter or an authentic copy to the registrar of the district court. Failure to comply with the provisions referred to in paragraph 1 will result in a decision arbitration cannot be executed, and all costs related to the making of the registration deed shall be borne by the parties. Chapter 60, 64, and 65, Constitution 1999, Number 30. The arbitral award is final and has permanent legal force and is binding on the parties. The arbitral award, which has been annotated with an order from the chairman of the district court, shall be carried out in accordance with the provisions for the implementation of decisions in civil cases whose decisions have permanent legal force. And third is that the authority to handle the recognition and implementation of the International Arbitration Award is the Central Jakarta District Court. This means that the final decision by the arbitration will have the same permanent legal force and it will bind on the parties as it will if the problem is brought to a district court. And as it is said here, that International Arbitration Award can only be recognized and implemented by the Central Jakarta District Court.
BANI, which is Badan Arbitrase Nasional Indonesia, is an arbitral institutional providing services in relation to arbitration, mediation, and other form of dispute resolutions. It is managed by a governing board and an advisory board composed of prominent public figures and business personalities. It is located in Jakarta with representative offices across Indonesia, and disputes that can be resolved through arbitration are only disputes in the field of trade.
This one is alternative dispute resolution types. There are consultation, negotiations, mediation, and conciliation. The consultation is an action that is personal between a certain party, called the client, and another party who is a consultant, who gives his opinion to the client to meet the needs of the client. The role of the consultant in resolving disputes is not dominant. The consultant only provides legal opinion as requested by the client, which subsequently makes decisions regarding the resolution of dispute to be taken by the parties themselves, although sometimes the consultant is given the opportunity to formulate forms of settlement dispute desired by the parties to the dispute. And there is negotiation. Negotiation is a means for disputing parties to discuss their settlement without the involvement of a third party. According to KBBI, or Big Indonesian Dictionary, negotiation is defined as a peaceful settlement of disputes through negotiation between the disputing parties. Through negotiations, the disputing parties can carry out a process of re-examination of the rights and obligations of the disputing parties in a situation that is mutually beneficial, by releasing or providing concessions to certain rights based on the principle of reciprocity. The agreement that has been reached is then set forth in writing to be signed and implemented by the parties. Also, there is mediation. Mediation is an intervention in a dispute by an acceptable, impartial, and neutral third party or mediator, and helps the disputing parties reach a voluntary agreement on the issues in dispute. According to Rahmadi Usman, mediation is a way of resolving disputes outside the court through negotiation involving a third party or mediator, who is neutral and doesn't take sides with the disputing parties, and whose presence is accepted by the disputing parties. And the last is conciliation. Settlement through conciliation is carried out through a person or several persons or bodies as intermediaries called conciliators by bringing together or providing facilities to disputing parties to resolve their disputes amicably. The conciliator actively participates in providing solution to the dispute issues. And then what is the difference between arbitration with mediation and conciliation? Arbitration is a settlement using the assistance of a third party or arbitrator, in which the parties declare that they will comply with the decision taken by the arbitrator. Meanwhile, mediation also uses assistance from a third party or mediator, but the mediator is only tasked with bridging the parties without giving opinions regarding dispute resolution, even though they both use assistance from a third party or conciliator. Conciliation is more formal than mediation. The conciliator can provide opinions to the parties on the issues in dispute, but these opinions are not binding on the parties.